So, very good morning to all of you. Today, our topic of discussion is industrial relation. So, industrial relation is basically your third chapter of BTech ECE fifth semester. Paper name is Human Resource Management, and the paper code is OEEC 506C. So, we are going to discuss about this industrial relation, about little bit about industrial dispute, reasons of industrial dispute, etc. Probably we'll be finding a little bit lengthy and some legal terms are there. But however, this is very important for your this human resource management chapter. It is going to be helpful for you whenever you will be joining corporate. So let us check what are the things we are going to study today. Number one, concept and definitions of industrial relation, concept of industrial dispute, causes of industrial dispute. Then we'll be talking about prevention of industrial dispute. At the end, we'll be discussing a little bit about conditions for good industrial relations, right? So let us start one by one. So first one is the industrial relations. The term industrial relations refers to the collective relations between the employers and the employees as a group. It underscores the importance of compromise and accommodation in the place of conflict and controversy in resolving dispute between labor and the management. So as the term indicates, industrial relation. So industrial relation means harmonious relationship between various industrial parties, specifically employer and the employees, labor and the management. There are some other parties like employee and the employer union and the government. So these are the major parties in the industrial relation. So making and harmonious relationship amongst all the parties is the concept of industrial relations. Okay. So features of an industrial relation: the employer-employee interactions, wave of rules. There are a lot of rules and regulations that are there in industrial relations. It is multi-dimensional. It is not a vertical or horizontal only. It is a multi-dimensional. So dynamic and changing. That is the industrial rules, regulation, policies are keep on changing as per the requirement. Spirit of compromise and accommodation. Everybody has to. Every party has to accept some kind of compromise, do some accommodation to maintain a harmonious relationships. It may not be always win-win situation. So it depends on the particular cases that how you are going to handle that industrial disputes. Spirit of compromise accommodation that we have already discussed next to the government. So government has a great role to play because they are the policy maker. They are implementing the policy. So that is the reason that the government has a great role to play. Wide coverage, it is not specific to a company, it's a nationwide, state-wise, company-wise, industry-wise, it varies. So its coverage is wide. And interactive and consultative in nature, that is all the parties will be discussing among each other and to come to a conclusion. Okay. Next, major factors that influence the industrial relations, mainly the institutional factors, economical factors, technological factors. So these factors is actually affecting the overall industrial relation process. Now let us understand what is industrial dispute or a conflict. When there is a conflict, what is a conflict? Differences in opinion. When there is a differences in opinion among the parties, like differences in the opinion of the employer and the employee, okay, union and the management, government and the management, government and the trade union. So if there is any differences in opinion about any issues, so that create a conflict. So there should be a difference or the dispute. The dispute could be between employer, employee, or employer-employee. Okay, the dispute must be pertain to some work-related issue. Okay, work-related issue. Next one, dispute must be raised by a group or class of worker. It is not an individual who is raising some issues about his salary or the increment or anything to the management. So that is not a dispute, okay, industrial dispute. When a class of worker, a group of employees having the same issue and they raising the issue together, then we'll be calling it as a industrial dispute or a conflict. Forms of industrial dispute. So there are several forms. We'll be discussing 4 types of forms like lockouts. Lockouts means when closing down of an undertaking or suspension of work or the refusal of an employer to continue to employ any number of person employed in him by him is called the lockout. I mean the employer, the owner of the company is shutting down an establishment for a stipulated period of time or indefinite period of time. That is called lockout. Gherao means, next one is gherao. Gherao means surround. In this method, a group of workers initiate a collective action aimed at preventing members of management from leaving the office. Okay, they are heroing the management people so that they cannot leave the office. Okay, until and unless their demand are being fulfilled. Next one is the picketing or the boycott. When picketing, workers often carry uh, or display signs, banners, placards, prevent others from entering the place of work, and persuade others not to join the strike, join others to join the strike, and boycott aims at disrupting the normal functioning of an enterprise. I mean, together the employee or the group of workers will be boycotting the work. I mean, and there's a work. So boycott aims at disrupting the normal functioning of an enterprise. Next one is the strike. So strike is temporary cessation of the work by a group of employees in order to express their grievances or fulfill some demand. So these are the basic forms of industrial dispute. There may be some other options as well, but as per our syllabus, we will be concentrating mainly on these four topics. Now, what are the reasons of this kind of why the people go for strike, or why they go for boycott, or this kind of activity? What is the reason? What are the common causes of that? So that we will be discussing. Number one, the wage. Wage is the most common factor. In order to raise the wage as per the market trend, their employees are going for strike. Right. Next one is the dearness allowance of the bonus. So the bonus needs to be given at an appropriate time and with a stipulated rate. So this also can be a cause of industrial dispute. Next one is the working conditions or the working hours. So employees may be thinking they are getting exploited. Okay, they are working overtime, but they are not getting the payment actually. So this working hours and the working condition needs to be changed. For that, this industrial dispute arises. Modernization of the automation of the plant and machinery. That is, they are demanding modernization of the automation, the plant and machinery, the age-old machines they are utilizing that are prone to so much of accidents. So that is the reason they want to change it. So that is the modernization they are demanding. Next one is the denial or the recognition of the trade union. That is, they have employees have developed a trade union, but the management is not recognizing the trade union. So that may be a cause. Defective recruitment policies. That is, there is a demand in most of the times that is son of soil needs to be hired, then the local people needs to be hired. If the management is not following, the local employees are demanding. I mean, local laborers are demanding for that, or maybe some other defective employment policy or the recruitment policy that may also create the issue. I mean, this industrial dispute. Irregular layoff and the retrenchment. That is, suddenly the employees are terminating. Employers are terminating the employees without any particular notice or without any specific reason. So that may also create the grievances. I mean, this industrial dispute. So how we are going to control this industrial dispute? How we are going to handle this industrial dispute? So there are several ways. Number one is the works committee. This committee consists of the representative of the workers and the employers. Under the Industrial Dispute Act 1947, works committee exists in the industrial establishment in which 100 or more workmen are employed during the previous year. It consists of an equal number of representatives of the workmen and the employer. I mean, this works committee will consist of equal number of representatives both from the employer and the employee. Next was the conciliation officer. Conciliation officer are appointed by the government under the Industrial Dispute Act 1947. And what is their role? He has to do everything for bringing a fair and amicable settlement of dispute. In case of public utility service, he must hold conciliation proceeding in the prescribed manner. He shall send a report to the government if the dispute is settled in the course of conciliation proceeding, along with the memorandum of settlement signed by both the parties. Where no settlement is reached, conciliation officer sends a report to the government setting forth the steps taken by him for the ascertaining the facts, circumstances related to the dispute, and the reasons on account of which the settlement could not be reached. The report shall be submitted within 14 days of the commencement of the conciliation proceeding. So this is the job of the conciliation officer. Next is the prevention of the industrial disputes. Next point is the board of conciliation. If the conciliation officer is not able to do that, then we'll be going for board of conciliation. The government can also appoint a board of conciliation for promoting the settlement of industrial disputes. The chairman of the board is an independent person, and other members may be 2 or 4, are to equally representing the parties, both the parties in the dispute, or all the parties in the dispute. What is the duties of the board of conciliation? To investigate the dispute and all the matters affecting the merits, and do all the things as it thinks fit for the purpose of including the parties to come to a fair and amicable settlement. Next one is a report has to be sent to the government by the board whether a dispute is settled or not within 2 months of the date on which the dispute was referred to it, right? So this is the job of the board of conciliation. Next is court of inquiry. The government may appoint a court of inquiry for inquiring into any kind of industrial dispute. A court may consist of one person or more than one person. In that case, one of the person will be the chairman. The court shall inquire into the matter and submit the report to the government within a period of 6 months. Next is labor court. The government has set up a labor court for dealing with the matter specified in the second schedule of the Industrial Dispute Act 1947, and these matters include the property of the legality of an order passed by an employer under the standing order. Okay, if the employer have passed an order that is that legal, so that they do check the application and the interpretation of the standing orders, discharge or dismissal of the workman, including or the grant or the relief of the workman wrongfully dismissed, withdrawal of any customary concession or privilege, illegal or otherwise of a strike or lockout, all the matters other than those specified in the third schedule, that has to be take care of the labor court. Next one is the industrial tribunal. A tribunal is appointed by the government for the adjudication of the industrial disputes relating to any matter specified in the third schedule. These matters are like wages, including the period and the mode of payment, compensatory and other allowances, hours of work and the rest on the interval, leave with wages and holidays, bonus, profit sharing, provident fund and gratuity. If the the disputes arises due to these causes, these reasons, then the industrial tribunal will be handling the issue. And the last one is the national tribunal. A national tribunal is constituted by the central government for the adjudication of the industrial dispute involving questions of national importance. So that's why it is called national tribunal. A national tribunal shall consist of one person only, to be appointed by the central government. A person who is or has been a judge of high court or who has held the office of chairman of the member of the labor applied tribunal is eligible for the appointment of this tribunal. So these are the prevention tools or the techniques we will be utilizing for handling the industrial dispute. Next, last topic of today's discussion is the conditions of good industrial relation. If you want to maintain a good industrial relation in an organization, what are the principles we should maintain? Number one is the compliance. Compliance is there is a rules, regulation, procedures within the organization. Both the party or rather all the parties should maintain that. If all the rules, regulation which are framed, signed by all the parties, if they are maintaining all the things, so definitely there will be lesser chance of industrial disputes. Relationship building, this is an over emphasis should be given on relationship building between the employer and the employee and the labor union, employer and the labor union. So emphasis on the quality of relationship, harmonious relationship should be created, should be developed. Good faith bargaining would be there between both the parties, but that should be in a good faith. And the grievance handling, that there would be grievances. If there is people, there would be differences in opinion, there would be grievances of the employees. Companies should take appropriate steps to handle those grievances at an appropriate time. The lesser the time the company will be taking in handling the grievances, that will help the organization to handle the grievances. Because if the grievances are not being handled at a proper time with an appropriate manner, that may create a huge industrial dispute. So that is the reason the companies should be having proactive grievance handling system that is going to help the company to maintain a good industrial relation, harmonious relationship. That is very important. So these are the parts of this industrial relations concept of your third chapter of human resource management. So it is very, very important, though I can understand that these terms are very complicated and seems very legal in nature. But whenever you will be working in an industry, these are the things you need to handle in some time. So that is the reason this part has been included in the syllabus. So it will be great if you can just go through the video once more. If you have any questions, please feel free to ask me in the forum that has been given to you. You can ask any questions at any point of time. So again, we'll be coming back with our the next chapter on this human resource management shortly. So till then, again, go through all the sessions carefully. If you have any question, please feel free to ask me. So thank you so much for attending the session.